Good afternoon, everybody, and welcome to our Landlord Lunch and Learn series presented by the Landlord Self-Help Center. This is webinar 2 of 3 of the series proposed for the spring. The rest of the series is scheduled for June 14th about hearing day and the order, what to expect. My name is Natalia Debsky, and today I will be joined by Ender Joseph, who is my colleague. We are licensed paralegals employed with the Landlord Self-Help Center. Please note, even though we are the Landlord Self-Help Center, we believe this information will be beneficial to both landlords and tenants. You can also visit our website at www.landlordselfhelp.com, where you will find numerous resources such as fact sheets, FAQs, modules, presentations, etc. Our website also contains information on how to contact us by phone, email, and in person. We will start today's webinar by showing an introduction video on who we are at the Landlord Self-Help Center and what services we provide. We will then have a video presentation on the notice of hearing and evidence at the Landlord and Tenant Board. This will take about 20 to 25 minutes in total. We will then have ample time for your question and answers, where you will have the opportunity to pose questions pertaining to this webinar in the chat. Okay, thank you everybody for participating in that. I will now pass the presentation on to my colleague, Ender Joseph.
Yes, thank you everyone for being here. Thank you, Natalia. So first, we're going to move into a very brief video, just letting you know what we do here at the center and just a brief introduction. Okay, thank you for being here.
Welcome to the Landlord Self-Help Center introduction video. The purpose of this video is to introduce you to the center and the services we provide. The Landlord Self-Help Center has existed since 1975 and was incorporated in 1977. It is a nonprofit community legal clinic funded by Legal Aid Ontario that operates with the mandate to support the small landlord community. According to our criteria, small landlords are those who live within the same property where the rental unit is located and offer up to 3 rental units in a basement, duplex, triplex, or fourplex. We are unique. The Landlord Self-Help Center is the only legal aid funded clinic meant to provide services exclusively to small-scale landlords. However, we are restricted to providing summary advice and brief services. We may provide further services if the client meets our financial eligibility test. The center educates and informs small landlords across Ontario. We help them learn and understand their rights and responsibilities as housing providers to ensure they are equipped to navigate the legal system. Ideally, we try to educate the public before they become landlords. Most of the time, we find ourselves educating landlords about their rights and obligations when dealing with existing tenants. The Landlord Self-Help Center helps small landlords with a full range of issues related to renting, from providing information we call before your rent, which includes everything a new landlord should know prior to committing to a tenancy agreement, to the eviction and collection process, and everything that you could imagine in between. In addition to advising walk-in clients, responding to email inquiries, and developing educational materials, we provide summary legal advice to over 70 clients over the phone each day. Out of the issues we assist clients with, termination and eviction related issues are the most frequent, such as non-payment of rent, disturbances, landlord's own use, agreement to terminate the tenancy or notice from tenant, and damages. Typically, the Landlord Self-Help Center helps 12,000 clients per year. We also have a multi-language translation services, which is a useful tool in breaking down language barriers when explaining complex legal issues to our clients. Due to our limited human resources, we do not assist with above guideline increase, applications, mobile home or trailer park issues, care home issues, commercial tenancy matters, and problems between head tenants and their roommates. We mainly provide summary advice. We do not provide legal representation. The Landlord Self-Help Center's website is designed as a learning tool and serves as the first point of contact for many inquiries. Our website contains general information on the Residential Tenancies Act and issues commonly encountered by our landlord community. It also has frequently asked questions, newsletters, fact sheets, podcasts, videos, etc. The Landlord Self-Help Center involves itself in lobbying for legislative and procedural law reform, which will benefit the small landlord community in Ontario. Lobby efforts are completed in the form of letters, submissions, participation in consultation opportunities, or petitions. We often engage our client community through the use of an online survey to gather input and feedback on particular issues to assist in our law reform efforts. In addition to participating in law reform and community development activities, the Landlord Self-Help Center develops educational materials and delivers outreach programs. Some of our learning tools include RTA fact sheets, quarterly newsletters, lunch and learn sessions, learning modules, frequently asked questions, all which are available on the Landlord Self-Help Center's website. We offer a membership program which includes a subscription to the quarterly newsletter and access to the members area of the website, where rental tools including additional terms to include in the standard form of lease, rental applications, inspection reports, and notices to enter can be downloaded. Thank you for watching this introduction video. We look forward to assist you.
Wonderful, thank you, Ender. Now we are going to do our second poll question. So if everybody could take a few seconds and participate in it. Ten more seconds. Thank you. Okay. And now I pass it back on to Ender, who's going to present the next video.
Thank you, Nat. Yes, so let's move on to the real reason we're all here today, is the next video, of course. So on the next video we're going to play, it's to deal with our topic today, after you file notice of hearing and how to prepare. In this video, you can expect to hear about how the notice can be received, what happens once you get the notice, important parts of the notice. Also, you'll hear a bit about evidence, how to serve evidence to the parties and at the LTB, what to include as evidence, how to call witnesses, and finally, you'll hear a bit about how to prepare for the hearing. So without further ado, I'll play that video now. Thank you.
Welcome to the Landlord Self-Help Center Lunch and Learn series. This is our second presentation entitled, After You File, Notice of Hearing and How to Prepare. In our previous presentation, we talked about opening an account on the Tribunals Ontario Portal and filing an application or linking an application to your account. Today, we will talk about what happens after you file an application or receive notification that an application has been filed against you. After an application has been filed, you will receive a notice of hearing. A notice of hearing can be received by mail or email. If you have a Tribunals Ontario Portal account and have linked the application to that account, your portal information will update automatically to reflect a scheduled hearing. If your email address was included with the application, you will receive an email notification that an application was filed, and subsequently receive a notice of hearing by email. If an email address was not included in your contact information on the application, the Landlord Tenant Board will send notification by mail. The notice sent by mail will include instructions on how to create an account on the portal and link the application to that account by using a PIN number. If you have any questions about how to create an account or link an application to your account, visit our website at www.landlordselfhelp.com and view our previous Lunch and Learn presentation. Once you review your notice of hearing stating that a hearing was scheduled, you will also read information in that same notice about a deadline for submitting any supporting evidence. Please take the time to read the information carefully, as this document will include instructions on how to provide evidence to the Landlord Tenant Board. You will also be expected to provide a copy of all documents to the tenant as well. Please remember that disclosure or evidence can be provided to the tenant by any of the methods listed on the Landlord and Tenant Board Certificate of Service and by email. Gather all information you wish to rely on to prove your claim or position. Be sure to properly identify each piece of evidence, whether by creating a table of contents or just simply using a pen or marker to label each document. This will enable you to properly identify the evidence when referring to them at the hearing. When you receive a notice of hearing, there are some important things to note. Number 1, file number, as the Landlord and Tenant Board would always refer to a case by the file number. Number 2, the hearing date and time. Number 3, hearing format, most likely Zoom. Take note of the Zoom link provided and have it readily available on the day of the hearing in order to attend. Number 4, phone number. Take note of the telephone hearing number if you are planning to attend by phone. We advise landlords to attend by Zoom as it is sometimes difficult to navigate the hearing while on the phone. All evidence must be provided to the Landlord and Tenant Board and the tenants at least 7 days before the hearing, and responding evidence to be provided at least 5 days before the hearing, unless ordered otherwise by the Landlord and Tenant Board. Responding evidence is evidence that addresses issues that are raised by the other party's evidence. As board hearings are not conducted virtually, service of evidence by email is very common and recommended. The rules state that all evidence should be emailed to the board unless email service is not possible. The email address that is used is ltb.evidence@ontario.ca. When serving by email, the evidence must be attached to the email as a PDF file with a separate table of contents. Do not include it in the body of the email. Evidence cannot be sent to the board using cloud-based delivery options such as iCloud or Dropbox. If you are unable to serve the board with evidence by email, you may mail the evidence to the board. The evidence would need to be mailed to the LTB regional office that is responsible for your file. If the evidence you are intending to rely upon is in document or picture format, you may mail those copies to the board. If you would like to include an audio or a video, it should be contained on a USB stick or CD, which will be returned to you after the hearing. Please note that if you choose to mail your evidence to the board, you are still responsible to ensure that the evidence is received within the deadline. If you miss the deadline, the board member will have discretion as to whether or not to accept the evidence. The member may consider the reasons the party provides, explaining why the evidence was not served in compliance with the deadline. As per the rules, some factors the member may consider are how late the disclosure was, the reasons as to why the evidence was not provided by the deadline, and whether there will be any prejudice to the other party if the evidence is accepted after the deadline. When it comes to evidence, it is important to ensure that you're only including evidence that is related and relevant to your matter. Evidence can be included in the form of documentation, pictures, objects, audio and/or video recordings, emails, text messages, social media, live testimony, etc. The board permits for parties to bring witnesses to provide live testimony for their matter. If you have a witness that is able to provide helpful evidence to your matter, you may ask them to be present at the hearing to provide oral testimony. However, if you feel that the witness may not be present, you may fill out a form that is titled Request for the Board to Issue a Summons. On this form, you will need to include information regarding the witness, why you believe the witness will be helpful and have meaningful testimony, and any documentation that the witness is required to bring. If the board accepts your request and issues the summons, you will then need to provide the summons to the witness. When submitting any type of evidence to the board, it is important to note that the adjudicator has discretion not to accept a piece of evidence. As per the rules, some of these reasons include: it is not relevant, it is repetitive, it is inadmissible due to privilege under the law of evidence, it was not provided to the board or the other parties by the prescribed deadline or an interim order issued by the board. On the day of the hearing, it will be your responsibility to enter the documents as evidence. To do so, you must refer to the document and have the adjudicator acknowledge this document. It is instrumental that you provide identical documents to the tenants, so that as you enter the documents as evidence, everyone involved is able to follow along. Be mindful that if you provide 10 items to the board as disclosure, but you only refer to 2 pieces during the hearing, the board will only include these 2 pieces. The other 8 will not be considered in the decision making. If you would like further information regarding evidence, you may refer to the practice directions on evidence, which can be found on the Landlord Tenant Board website. In order to be ready for a hearing, there are a few steps you can take. Some of these may be: make sure you know your case. It is crucial to know every detail of your matter, so if the adjudicator asks you clarifying questions, you are ready to answer them. It is also important to review the responding party's evidence to ensure you familiarize yourself with what they may bring up at the hearing. Be organized. Ensure all of your documentation is in proper order to avoid any delays that may be caused by having to go through your documentation. Observe hearings. You may email the board and ask for the Zoom link for the hearings that are scheduled, as hearings are open to the public. If you do this, you are able to observe hearings that may be similar to your case. Zoom account. Ensure you are familiar with Zoom, as this is the platform that is used to conduct Landlord Tenant Board hearings. It is good practice to check if your account is working prior to the day of the hearing. As the hearings are on Zoom, ensure you have good internet connection. Poor internet connection can result in not being able to properly hear the member or other parties, or losing connection during the hearing. These are things that may lead to interruptions and delay the hearing. Thank you for watching our second Lunch and Learn presentation. Please join us for our next Lunch and Learn on June 14th, where we will discuss more about what to do on the day of the hearing and what to do when you get your order.
Okay, thank you everyone again for joining us. So that marks the end of our video presentation. We'll move right into our question and answer segment. I believe we do have a few questions from the audience, and then we do have a list of prepared questions based on questions that's been posed to us at the center that we'll be happy to answer as well for you today. So without further ado, I'll ask Natalia to start off our question and answer segment.
Thank you, Ender. Yes, so our first question we have here: I have served my tenants with the notice of hearing next month. They agreed to communicate through email as per the lease agreement. I emailed them through email. What is the next procedure as to file the certificate of service to the Landlord and Tenant Board? Please advise. Thank you. So when it comes to the notice of hearing, this isn't a document that the obligation is on the landlord to serve on the tenant. The board will serve a copy of the notice of hearing on the tenant, or the responding party. If you want to, send them a copy of the notice of hearing, either as courtesy or to ensure that they're in receipt of it, that is recommended to do so, because then you can, in case the tenant or the respondent, I should say, doesn't appear at the hearing, you can advise the adjudicator that, they were well aware of it, you sent them a copy of the hearing, just to, eliminate the potential for them to say they didn't know that there was a hearing. And with respect to, I just wanted to touch upon the agreeing to communicate via email as per the lease agreement. There is actually a form that we encourage landlords to sign with their tenants. It's on the Landlord and Tenant Board website under forms. It's the consent to service through email. And we recommend for both parties to sign this in case there's any issues with service, because something was served via email. This is a consent that both parties are agreeable to receive notices or whatever documents you select to be served via email. And the last part of the question regarding filing the certificate of service, you can just upload that to your portal.
Okay, thank you, Nat. We also have another question. It says, I was given 2 hearings on the same day. I was on the phone for one and on Zoom for the other. I waited there 3 hours, and when my hearing came up, one of the adjudicators was rude and disrespectful in her approach. So we won't touch too much on the adjudicator portion, unfortunately. That I'm sorry you had that experience. As licensed paralegals, Natalie and I have actually appeared at the board, and I'm sure in many instances have had more than one hearings in different rooms. What the best practice to do would be to sign into one first, let the adjudicator know that you are scheduled for a hearing in another room, so that can explain your absence. And so unfortunately, you would be expected to move from one room to the next during that portion of your day. But again, just let each adjudicator know so that you can explain your absence away that way. Okay, thank you. So I believe there are more. Natalie, sorry, do you want to take the other one, Natalia?
Yes, absolutely. Thank you
Thanks.
for your questions. These are great. How do I access other tribunal Zoom meetings that are open to the public? So that's a great question. You can do so by emailing the Landlord and Tenant Board. The email is ltb@ontario.ca, and you can ask for a Zoom link to the hearing scheduled that day. And then you'll be provided with one. And if anybody, the moderator asks who this is signing in, you can just say that you're an observer.
Okay, thank you. Another question, my tenants are avoiding all communication with me. They let all calls go to an answering machine service and do not answer the door. Mail goes to the post office and registered mail ends up returned to me. How can we ensure that service of notice is found acceptable to the board? So as Natalia stated earlier, the Landlord and Tenant Board does take the onus on themselves to serve any notice of hearing. So the onus would not be on the other party to serve the opposing party with a notice of hearing. So that would take care of that. Also bear in mind that the only requirement from the LTB when serving any notice at all is that you serve the notice to the last known address. With that being said, if the last known address is the address of the rental unit, then any method of service listed on the certificate of service will be acceptable. So just use one of those methods. If you push it under the door again, if this is the last known address, then that's all the requirement that is expected of you, and so your requirement would be met. Thank you.
Thank you, Ender. Okay, we have another 3-part question here. So what happens if the tenant, oh, my apologies, four-part question. What happens if the tenant corrects all the issues before the notice of hearing? So that's very case specific to the hearing that you're going to appear to. I can give an example. If it's an L1, so for non-payment of rent, then it is void. They voided the application. If they've paid all the rent up to the date and potentially the filing fee, if that's also something that you're looking to collect. If you have any questions about other hearings and how a tenant can void, we definitely encourage you to give us a call and we'll be able to better assist you with that. The next part of the question is what happens if the tenant does not show up in the hearing? So this has definitely happened to myself before, and I'm sure I could speak on vendors' behalf as well as legal representatives. If the tenant does not show up, you can still present your matter. It's important to note that the adjudicator always has discretion that they may exercise. So just because the tenant didn't show up at the hearing doesn't mean you'll automatically get an order. However, it will be an uncontested matter. Therefore, you'll be able to present your side of your case, so your application and your reasons for filing and serving the notice, as if the tenant was there, but the tenant doesn't have the opportunity to respond. If the adjudicator is satisfied with the evidence presented, they will issue an order in the tenant's absence. It is just a side note, it's important to note the tenants do have 30 days to motion to set aside the order once it is issued. But to answer your question, you can definitely proceed and an order can be issued. And the last part of the question, can the landlord ask the board to have the tenant to pay the landlord back for the filing fee? Yes, you can. You absolutely can ask the adjudicator to include that in the order. Thank you for that question.
Okay, just a reminder as well that we'll only be addressing questions pertaining to today's webinar. If you do have any other questions outside of this, we do encourage you to visit our website at landlordselfhelp.com. You can also call us and book an appointment to come in and speak with us in person if you prefer that option. So to answer the next question, it says, does regional office only receive filing via mail because they have no in-person clerks working to accept courier? If we need to courier, do we need to send it to 15 Grosvenor in Toronto? So the regional offices only does accept mail. Since the pandemic, all offices has been closed to in-person service. So you will have to mail it to one of the offices. It does say on the board website that you can courier your application to 15 Grosvenor Street in Toronto, and that's something that we do know has tended to work in the past and continues to. It does also say on the Landlord and Tenant Board website that you are encouraged to mail your applications to the regional office that's closest to the rental unit. So all the offices and addresses are listed on the Landlord and Tenant Board website. And again, I personally have filed by mail and not necessarily courier, but I have used Canada Post, the registered mail option, and applications have arrived as well. So that would be another option for you. Okay, thank you. Do we have any other questions, Natalia?
Yes, we do. Okay, so what do we have here? What will happen if I receive a notice of hearing and I'm unable to make it that day as I'm out of the country? Great question. This does happen sometimes. Ultimately, you still need to attend at the hearing. So this kind of goes to what we spoke about a few minutes ago, that the adjudicator has the discretion to render an order that's uncontested. And it won't look great in the eyes of the board if you're the applicant and you don't show up to your hearing. So the short answer is ask somebody to appear on your behalf to ensure the matter is spoken with. If you have a lot of time to have a discussion with the opposing side, depending on how the relationship is, you may ask if it could be rescheduled or adjourned. However, just to answer the question, somebody does need to appear, and it's always best to make sure someone will be there, because as we know, there is a bit of a wait time. The last thing you would want to do is wait months for a hearing and then you have to start the process over.
Yes, most definitely. Another question we have, can we mail in evidence or courier evidence when preparing for a hearing? So this question was not specific in determining, are we speaking about mailing in evidence to the Landlord and Tenant Board or to the tenants? So I can answer both. If you're speaking about Landlord and Tenant Board, the direction on the notice of hearing specifies that you can upload it on the portal, or you can send it to the ltb.evidence@ontario.ca. Emailing is the most common option and it's easier, obviously. So the board does give you the option to email to them. There is no option for mailing the evidence to the board. Again, so I would just encourage you to follow the directions as described on the notice of hearing. Sometimes it does tend to change. You may see, you may have had a hearing last year that mentioned nothing about uploading evidence on the portal. I saw one recently, as recent as last month, that gave you the option to upload on the portal. So we just encourage you to review the notice of hearing package carefully and just follow those directions. With regards to evidence to the tenant, you can definitely courier that the evidence to the tenant. Again, just be sure that that evidence is going to get to the address within before that 7-day cutoff period. Okay.
Thank you, Ender. Okay, we have another question here. Oh, this is a good one. What happens if I miss the deadline to file my evidence? So you never ultimately want to miss a deadline, but if it does happen, it probably happened on accident. But it may be an issue, and that's the honest answer. There's a reason that the notice of hearing said that all evidence must be provided within the 7 days, reply evidence within 5 days, but it is important to always look at the notice of hearing, because I've personally seen a 5-day deadline for evidence and a 7-day deadline and a 10-day deadline. So just make sure you read it carefully and thoroughly. But if it does happen, I mean, the adjudicator has the discretion. I've seen where the evidence was filed with the board 6 days before the hearing, and I've seen the adjudicator say that's okay, because they argued that it was 1 day late, and the opposing side the responding side did not have taken issue with this. But I've also seen an adjudicator not accept evidence that was filed 5 days before the hearing. So ultimately, the adjudicator has the discretion. They will also look at whether or not permitting evidence that was filed late will cause any prejudice to the responding party. And what this can mean is that if, for example, the landlord files the evidence 3 days before the hearing and they really want to rely on it, the tenant opened their email the next morning, so technically they've reviewed this evidence 2 days before the hearing and it's 100 pages of evidence. Well, by only giving the tenant maybe 1.5 days to respond can be prejudicial, because it doesn't give them an opportunity to respond to all of the evidence, to read through it and potentially, get legal advice. So they will definitely consider if there's prejudice in allowing the evidence to be filed. But our advice is just to diarize, ensure that it's filed. I always recommend to file 1 day before the deadline if you can. So the deadline 7 days, submitted 8 days before. That way you know that you've submitted it for sure and it won't be an issue.
Okay, I believe those are all the questions that we have. So we'll move into a few prepared questions that we would like to answer that we think might be beneficial to you. Again, these are questions that we fielded at this Landlord and Self-Help Center, and we believe that you might get some value from them. One of the first ones we've heard a lot, it says, I'm not tech savvy, so I am not sure how to access Zoom to log into my LTB hearing. Zoom, there is a tutorial portion of Zoom that you can possibly review and get familiar with that. But my advice to you is that if you're not tech savvy at all, this might not be the time, that you wish to do a trial and error. Again, the notice of hearing package that you receive does have a telephone number included, that if you're not tech savvy or you're not familiar with Zoom or even have a computer, you can definitely call in by phone and be able to participate in your hearing that way. So that would be my advice to you, to again use the telephone hearing option that's available. Natalia?
Thank you, Ender. Okay, so my tenant and I have come to an agreement before the date of the hearing. Should we or should I still attend the hearing even though we came to an agreement? Absolutely, yes. You never want to not attend a hearing on an assumption that the matter has been resolved. There's a few reasons for this. So the first one is that a verbal agreement sometimes may not be as easy to enforce if it's broken, right? So that's the first issue. You want to have something in writing, and if you have an opportunity to have an adjudicator write an order with the terms, that is ideal, and that is something that you can do at the hearing. So if you and the other party have resolved the matter, you just advise the adjudicator that, you know, this is on consent and these are the terms that we've agreed to, and you will get a board order outlining these terms, and that order is can be enforceable depending once again on what's included in the order, if there is a default of the terms. So definitely, yes, attend the hearing. I myself have been in a situation where when I was representing a landlord, and I thought that we came to an agreement, everything was, you know, ready to go. We go to the hearing and the responding party says, no, I actually don't agree. I want to go to a hearing. So if I, you know, trusted what they said and that we're going to agree, and they wrote something out, they wrote an email to me, they said, you know, these are all the terms. And then we go in front of the adjudicator, and last minute they say, no, we're going to a hearing. So in a case like that, it would be, you know, very, very prejudicial for the landlord to just, you know, go based off the responding party's word. So once again, always best to go to a hearing.
Definitely. Another question we have, it says, I am a landlord. I am not confident when speaking English. Can I have my friend help me translate on the day of the hearing? This is another common question as well. And yes, if you have a friend, it doesn't necessarily have to be a paid translator. If you have a friend that, you know, that's trusted, that is willing to help, you can definitely have that friend appear at the hearing with you. And at the beginning, before you begin, you would just let the adjudicator know beforehand that, or have your translator advise that they'll be translating for you, and that would definitely be fine.
Thank you. Okay. What happens if the adjudicator does not get my evidence, but I sent it to the Landlord and Tenant Board via email? So this also has happened to me a few times. I'm not quite sure why, but it was emailed over to the board, and we get to the hearing and the adjudicator says, we don't have your evidence. So I always like to be prepared. And this is what we talked about in the video as well, to be organized, to be prepared and be ready, you know, expect the unexpected, so to speak. So you always want to make sure that you have evidence of serving any document. As you know, there's a certificate of service, but when it comes to evidence, have a copy of that email that was sent as a PDF ready to go in case you need to submit proof that you've sent it, or a filled out certificate of service, which you could have also uploaded. If you're going to go the certificate of service route, you fill it out, you say that you served the tenant and the board with the evidence, and you can attach the email that was clearly time-stamped and that was sent to the board, and you could file that. If you did not fill out a certificate of service, you can just advise the board that this was sent, you have proof, and you can forward the evidence right now if you know that will get received. And then the board may give you an email that's specific to the hearing. So the adjudicator will get it right away, and you just re-forward it. Make sure you re-forward it to include that it was time-stamped, so there's no dispute of you not serving or filing the evidence in compliance with the deadline.
Thank you, Natalia. We have a few more questions from our audience. Again, thank you for your questions. Next question says, if you email your evidence, do you also need to upload it to the portal or vice versa? So no, you don't. The hearing package does give you the option to do either or. So again, if you upload it to the portal, you do not have to send a copy of your evidence by email. And also if you choose the email option, you don't have to upload it to the portal. Okay, thank you. Natalia, there's another question there as well. I can read it for you. It says, just a general question. Oh, okay, it has to do, it says, can I use text messages as evidence? We'll do that one first, if you don't mind.
Yes, absolutely, you can. You can definitely use text messages with evidence. I think, as evidence. I think it's a great way to demonstrate communication. We always encourage to have any correspondence in writing in any event, and this is why, because you can prove what was said. You can also prove the time, the date, right? And it really, I think, establishes a timeline of events to substantiate and to support your application and your notice. So if you're going to use text messages as evidence, you can screenshot them and put them into a PDF format and email it to the board that way. That's how I've done it in the past, and I've seen it being done like that. And you just want to make sure with text messages, because depending on how you download it or how you screenshot and how you put it in a folder, you want to make sure that they are in order, because the last thing you want is for the adjudicator to have to ruffle through a PDF document or papers if you're mailing the evidence in. So what I recommend is, if you're going to screenshot the messages, you can put them on a document, make sure they're in order, and also number the pages. So you can always refer to a communication that happened, for example, on this date on page number 4. And that just facilitates the evidence, and it won't cause any unnecessary delay that the adjudicator, is ruffling through a document or papers.
Yes, there's a general question here. It says, it's not easy to find reliable paralegal service. Does the landlord self-help website have information about paralegal service or provide some paralegal service listings to help the landlord? So we do not provide paralegal service as representation at a hearing. What we do is we refer you to the Law Society of Ontario website. They do have a referral services where you can find reputable paralegals, and they do offer a free 30-minute consultation, so you can speak to one of your choosing and decide if that's an option for you. Thank you. Natalia?
Thank you. Okay, so we have another question over here. When can my evidence be excluded? Okay, so I think in this situation, it's you've submitted evidence, and then you're excited to speak to it, and you feel like it'll be very helpful, and then it gets excluded. So that does happen sometimes. It's important to note that the adjudicators or members, they only hear evidence that is relevant to the matter that is being heard. And the board is very strict on this. So for example, if you are at an L1 hearing for non-payment of rent, and you submit evidence of damages to the property that you would like to collect, the board won't look at that evidence. They won't look at the damages. Your whole place could be torn inside out. They will not take that into consideration when making the order for the L1 application. It is crucial to know and to be aware that any issues you have, you need to ensure you're serving the proper notice to deal with those issues, because it's not that you can go in front of the board and say, well, I'm here for non-payment of rent, but while I'm here, let's talk about XYZ damages or the way the tenant speaks to you or anything like that. You're there only for the application you filed. So, and any other application any other evidence that doesn't have to do with that application will be excluded. And once again, we'll reiterate it, the adjudicator has discretion. So what you think may be relevant versus what the adjudicator is going to determine whether or not something is relevant, it's up to them at the end of the day. But a good rule of thumb to avoid your evidence being excluded is to just make sure the evidence you're providing is directly related to the notice that you served and the application that's being heard.
Yes. So we're coming close to the end of our segment. I guess we're going to take about, what, 2 more, Natalia? Is that okay? Yeah. Okay, so we have another one here, and this one is very important. This is one that we get at the center quite a bit. It says, I have witnesses for my LTB hearing. How can they appear if the hearing is conducted through Zoom? So one thing to bear in mind is that when you're presenting your evidence, if you have witness, they're supposed to be independent or give testimony independent of what they hear from you or gather from the rest of the hearing. So if you have witnesses, you're not expected to be in the same room that you are presenting or listening to opposing party presenting. So you would have to, if that person does not have reliable connection or access to Zoom, and they're relying on you to provide that access, you would have to have them wait outside of that hearing space, maybe in a different room, until it's time for them to give evidence, and then you can call them in. Once they've already given their evidence, they can stay for the remainder of the hearing. So you would definitely have to have them sit in separately. If they have access to Zoom or at their own computer and are appearing from somewhere else, you can just provide them the link that was provided to you for the hearing, and they can appear independently. But if you're definitely sitting together or expected to be in the same space, just know that they cannot be in the same room or in earshot of what is going on while you're presenting your matter before you call them. So when you go in, you let the adjudicator know that you have witnesses appearing. You'd let them know how many witnesses. And again, if they're in your vicinity, you let them know. If they're appearing separately, you would be expected to provide the names to the adjudicator so the adjudicator can let them out into a breakout room, and again, not be in that setting where the actual hearing is happening. And then the adjudicator or a moderator would have that person led into the actual hearing space when it's time for them to testify. Okay, Natalia, final question as wrap up?
Yeah, thank you, Under.
Yes.
Okay, last question. I got my notice of hearing and I noticed that it is only 1 page long. Is this normal? No. A notice of hearing is not only 1 page, it is at least 5 pages. So ensure that you have the notice of hearing, there's a copy of the application, depending on what hearing it is. It could be an L1 hearing, you have to have the update form, request to accommodation form. But once again, things change. I've seen a notice of hearing that's only 3 pages, for example. I've seen one that's 5, and I've seen one that's even more. So when you get the notice of hearing, if you feel that it's incomplete, trust your gut and email the board and just ask if this is the complete notice of hearing. And if you do get your notice of hearing via email, it's important to note sometimes that email you can't respond to. It should say at the bottom of the body of the email not to respond to this email address. So we encourage to flip that email to ltb@ontario.ca. and just confirm, ask why your notice of hearing is only 1 page in this case, because that is definitely not a complete notice of hearing, and you may very well miss information that's going to be very important to your matter.
Yes. Well, thank you so much, Natalia, and thank you to our audience for joining us today. Just a reminder that if you have any questions not relating to today's topic, you can definitely visit us, our website at landlordselfhelp.com. You can call us, or you can book an appointment to come in and speak to us one-on-one. Before you go, we just wish to remind you again about our third segment in the series. The next Lunch and Learn date is June 14th. Obviously on Wednesday. It starts at 1 p.m. It's scheduled to be about an hour, and that topic would take us further into this segment. We're talking about hearing day and the order and what to expect after you receive an order. So that would be very interesting, and again would be a great conclusion to what we're talking about here. Also, as a reminder, don't forget to keep an eye out for our survey. Just let us know how we're doing, what we can improve on. We really appreciate your feedback. So again, we hope to see you at the next Lunch and Learn on June 14th. And before you go, if you just spare us a couple of seconds just to finish our complete our final poll, that will be presented by Natalia. Thank you so much again.
Well, yes, so that brings us to the end of our Lunch and Learn. Once again, I'll reiterate what Andrew said. Thank you so much for joining us and interacting with the presentation. We hope you all learned something that's very informative and will assist you in being landlords with your tenancies. So thank you, everybody.
Okay, thank you.